Good afternoon. Welcome to your first intra-session of the conference. And thank you for making my session your first intra-session of the conference. If you look around, there's quite a few empty seats, but if you're just coming in and you'd like a prime seat, there are plenty of seats up front, as always. Feel free to take one. I will not be offended if you have to step out before the session is over. I wish you hadn't, but I will understand. Many people are trying to get overlapping sessions, trying to squeeze in lunch. It can be overwhelming, but please don't feel overwhelmed. Do what you can do, and I hope that you enjoy all of the sessions and all of the conference events that you can attend. Before we get started, I have just a few reminders. First, I'll introduce myself. For those of you who do not know me yet, my name is Anne Marie Weissman. I am the director of the Policy Development Group. And I say that slowly because I've been that for 8 days. So, previous to that, I was the director of the Policy Coordination Group. And you might say, well, what's the difference? And I'll say, not much. I previously worked on loan issues as my primary focus, and now I'm switching over to work on the general provisions, verification, some other more general issues. So professional judgment is definitely one of those, and I'm looking forward to working in this new role and hopefully working with many of you on different issues that you encounter. My name is at the bottom of the slides and in the program. In case you're not aware, for the department, all of our email addresses are our first name dot last name @ed.gov. So we cannot hide, nor do we want to. We encourage your questions. If I'm not the proper person to answer it, I will refer it on to someone who is, but we'll make sure we get your questions answered. Prior to my time at Policy in the Office of Post-Secondary Education, I worked within FSA, within Federal Student Aid. I worked in the training group as a manager and as a training officer. And prior to that, I worked in program compliance. So I've got a variety of different positions within the department. But prior to that, I worked for many years at schools and working in admissions and financial aid, working a little bit in housing. I've gotten to know some of what you're experiencing on your campuses. And I continue to try to stay relevant by keeping in touch with people like you who work directly with the students. And I thank you for the work that you do. I'd like to talk today about some of the flexibility that you have. I know that that can be uncomfortable for some people, but hopefully as you experience the session and as you get back to your campuses, you'll develop a comfort level with that. Again, a couple other quick reminders. First, this session is being offered 2 other times, so if you love it and want to tell a friend, it is being presented by me on Wednesday, tomorrow, at 12:15 in room 1A, and then again on Friday, the last session of the conference. So it since if I go first, I have to go last. That's on Friday at 10:05 to 11:20. So if you are hanging out till the end of the conference, you will see me there. Also wanted to remind you that there are evaluations that are coming out to everyone who registered for the conference. So if you registered, you will get an email reminding you that we would like your feedback on the whole conference, but also on the sessions that you've attended. Like your Uber driver, I would appreciate your 5-star rating. However, if you do not feel it merits a 5-star rating, please email me and let me know what you would have liked to have seen that is different, something that could have improved the session. Other feedback is certainly welcome. I really do appreciate hearing from people that attended the sessions and getting a sense of what you liked and what you'd like to see different for in the future. So with all of that said, we'll get started. Professional judgment. It is a little intimidating to some people, but after you attend this, it will not be intimidating to you. I use some abbreviations on slides just because I don't like to get too lengthy. Many of these are abbreviations that you know, things like AGI for adjusted gross income, Code of Federal Regulations, we have COA for cost of attendance. These are things that you generally will know, but if you are passing along the presentation to someone who is not in financial aid, it can be helpful to have these listed out for you. We continue with things like the Higher Education Act. One that you may have worked with and not really been as familiar with is the Income Protection Allowance, and we'll talk about that as we go through. What I'd like to do today is start with kind of the resources that you have. We usually save this for the back of the presentation or for the end as you're running out the door and thinking about other things. And I just want to make sure everybody is aware of what we have out there for you. We'll do an overview of professional judgment, and then we'll talk about kind of how you can do those adjustments, whether you're changing the cost of attendance elements, whether you're changing the data elements in the EFC, why it might be to your benefit to do one versus the other. Then we'll touch on dependency override, parental refusal to complete the FAFSA and to provide support, and then also denying and reducing direct loans. That's quite a lot to do in the amount of time that we have, and I will warn you, my mother has always said I have a habit of making a short story long. So, that said, I'd like to allot some time at the end for questions. If you are getting to the point where you're getting antsy and you can't wait anymore and you think I'll never stop talking, feel free to proceed to one of the microphones that we have. If I don't see you, feel free to kind of wave at me and get my attention. So we'll start out with those resources that I mentioned. First of all, we want to start with the Higher Education Act. The statute is what gives us the authority to do what we do. Professional judgment is kind of special in terms of the financial aid arena. Section 479A is where special circumstance authority is mentioned in the Higher Education Act. The Act does not actually use the phrase professional judgment or the term professional judgment. That is something that it's come to be known as. But that special circumstance authority is the hallmark of what professional judgment is. Generally, that's where you find the information that you need on what we call PJ. Section 480D7 also touches on dependency override. So that is a form of professional judgment in a way. I like to think of them as very different, but there are similarities, and so again, we include that in this session, and we'll talk about both. Generally speaking, there are not regulations that strictly outline how professional judgment works. Congress, when they wrote the law, wanted it to be something that the department did not interfere with. How often do you hear that? Many times what we say to you is, there's statute, and then after that we go and regulate, and we have all of these details about what you are supposed to do. Here, it's like we're giving you a gift. We are saying to you, we are not telling you how to do this. You have flexibility. That said, because in so many other cases, we are very strict and very detailed about what we want you to do, some people then get very uncomfortable with the idea of us saying there's flexibility. And they tend to not want to use it because they're afraid. And they think, well, if I do this and it turns out not to be correct, somebody is going to come back and say I did it all wrong, and then there's going to be liabilities, and it's a problem. So they don't want to use it because they fear getting in trouble. And so my goal today, if I can accomplish nothing else, is to remind you that that flexibility is there for the benefit of your students, and also to some extent then, in turn, for your institutions. But I'd like to focus just that first minute on students. The idea here is that if you decide you are not going to ever use professional judgment, the fear is that there could be a student out there that you could help that you miss helping. I would not want to see that happen. That said, we don't require anyone to ever use professional judgment. You are the professional. We empower you to take that and make your decisions. Your institution may decide we are not going to do professional judgment. And I will never say that that's wrong or a problem. You have that flexibility, so we're not going to take that away from you. But I would say take that pause and think about it before you ever say, we will not do this. Before you write a policy that says we're not doing professional judgment at our institution. Again, nobody is making you, but think about what it could mean to the student who otherwise would not have the aid that they may get under professional judgment. So generally, there are no regulations about professional judgment, but you're in financial aid, so you know that for every question, the answer is, it depends, or there's an exception to that. Now, some people like that, some people not as much. So I'll put it out here for you now. The only regulations we really have are surrounding denying or reducing direct loans. That is a very small part of professional judgment. That's in 685. Part 685 they are the direct loan regulations. So it is very narrow and very specific to that item. All of what I think of as the good stuff of professional judgment is not regulated. Therefore, the office that I'm in, writing regulations, we're to stay out of it. This is not our role. Congress has absolutely stated that we are not to regulate, so we don't. That said, for many years, when you would call or email the department or see one of us out there in the field, and you would ask your professional judgment questions, what we would often say was, I'm sorry, we're not able to regulate that, so we really can't give you advice. A couple years ago, one of the training officers and I got together and we said, you know, maybe it's time to pitch that again. Maybe it's time to see if we can kind of get out there and give people some suggestions, not telling you what you have to do, but giving you ideas and giving you just some general information that you can take back to your campuses. We were very excited to do that, and I'm very excited that for, I believe, the third year in a row, we're here offering this session. And if you attended the session, the general session earlier this morning, you'll know that there are about 1,500 new financial aid administrators or people who have never attended the conference before. So if you've not attended before, this is a great opportunity to learn about professional judgment. And if you have attended before, hopefully you're hearing some nugget that's a little new. We have a lot of professional judgment guidance out there. The Federal Student Aid Handbook has a wealth of resources in general, but Application and Verification Guide, which is Chapter 5, has some information in there about professional judgment. There are many Dear Colleague letters out there that have pieces of information about professional judgment. I've listed them here on the slide for you. You can take a look at those. I've also included the topical items that are part of that so you have a sense of what you're looking for. If you want to look specifically for unemployment benefits, you can look at Gen 0905 and 1104. So remember, all of these are general Dear Colleague letters. When you go and you look on IFAP, if you're new especially, I will give you this tip. The first time when we had restructured IFAP, I looked at it and I was looking for a GEN or a GEN Dear Colleague letter. And I went and I was looking down the list, and as I was looking, I thought, well, there's not one with that number. And then I realized the beginning ones are things like ANN for announcement. So you have to scroll down. So if you haven't done that yet, take a look at the Dear Colleague letters. They're in there by year. Some of the older ones are archived, but they are all still available. I did check the links before I submitted my slides. So back to that overview, some key concepts about professional judgment. The first thing, which we've already talked about, is that the department cannot limit the financial aid administrator's authority to do professional judgment. We want you to make sure that you have adequate documentation to perform professional judgment. We also want to stress that everything is case-by-case basis. So you cannot apply professional judgment to a group of people, even if they're in the same situation. And we'll talk about that more as we go along. Remember that the same situation may seem the same up front, but it may not have the same impact on the back end. So as we're going through the examples, you'll see where that might come into play. We also want to talk about, again, the idea of cost of attendance items versus the elements that go into the EFC. Many years ago now, you were able to just change an EFC as part of professional judgment. That did change, and I think that was a good change that was made. We want to make sure you're understanding the data elements that you're changing and what effect they'll have. So you need to know a little bit about the EFC calculation. We'll do examples coming up about that as well. And then we'll talk about what treatment is appropriate for the special circumstances that you're seeing. We want to make sure that we give you some do's and don'ts. Again, just putting up some guidelines for you, trying to help you. Not specifically telling you what to do, but if you came to me and said, can you give me some advice on this, what would you do? Again, what I do is almost not really relevant. It's more a matter of, here's the things you need to know in order to know how to do this. We want to make sure you're always making award year specific decisions. Something that impacts someone one year may not impact them in the same way the following year. So even if it is a situation that could occur for multiple years, you're still reviewing the file every year, you're still documenting the situation. Now that said, sometimes the documentation may last for multiple years. It may be that it goes for a 2-year span, or it could be that it's longer. You just want to make sure that you believe it's enough to document the situation that you're trying to document. We also want to make sure that when you're thinking about documentation, that you're using documentation provided by a third party, a neutral party, whenever possible. So we also want to remind you by the same token to remain flexible. Years ago, in my last year of working in an institution, I had a student who came to me and she was looking for some extra help. We talked about her situation, and upon learning more about her situation, I began to think that professional judgment was really the tool that I needed to make things right for her. She was having a lot of difficulty getting documentation of her situation. The first issue that I had with her was that she was being supported by her grandmother, but everyone believed that the grandmother was actually her mother. Nobody seemed to know. Nobody in the community, nobody at her school, from secondary school, from high school, nobody knew. So she was having trouble finding a third party who could document it. But I knew that that was just the bottom part of their problem. They had some other situations that I wanted to try to help with. They explained their special circumstances. The grandmother and the student came into my office. The grandmother was in tears. She so much wanted to help her granddaughter, but I explained to them that she wasn't eligible to fill out the FAFSA form because she was the grandmother. She had never adopted the student, so that it had to be either the mother or the father filling out the form. Long story short, if that's possible, the student was trying to find somebody who could explain this situation, and again, they really had no one. So what she explained was that the father was never in the picture. She did not know who her father was. Her birth certificate said unknown. The mother was somewhere that we could not contact her. She had been in rehab, and when she was discharged, they did not know where she went. We finally settled on signed statements from the student and from the grandmother. That pained me to do. The financial aid administrator in me said, oh, I don't like the idea of that. I need third-party documentation, preferably 3 letters that support what the student is saying. And I didn't even have one. I felt like I went home at night worrying about an auditor coming in or worrying about the Department of Ed coming in, doing a program review. And the more I thought about it, the more I got comfortable with it. It really was the only thing we had. So what I ended up doing was I wrote a letter to the file or a memo to the file as well, just to say, I met personally with the student. I met personally with the grandmother. I collected their signed statements because there really was nothing else. And by the end, I felt really good about the decision I made because this student could not have come to our institution otherwise. This is what she needed. She needed someone to put a human face on the federal programs for her. When you are working at your institutions, you are that human face. You are the person who represents the possibilities that they have through education. Now, we're not saying every case is an exception, but when you have the exception, think about what documentation is possible, think about what's practical, and then think about what you really need to do at the end of the day to make the right decision and to document it so that if someone were looking at your documentation, they would say, yes, that decision makes sense. That's really all we're going for here. It doesn't have to be any more complicated than that, and you don't have to stay up at night because I already did that for you. We want to make sure that you're not trying to directly change the EFC. As I mentioned earlier, that was an option many, many years ago. It has not been for many years now. You also cannot try to circumvent the law. So we can't have you saying, I don't like how the formula treats this, so I'm going to use professional judgment on students so that condition doesn't apply to them. We have some situations where that might come into play, and we'll try to get to those in the examples. But the key point on this slide that I want to mention is the idea of not establishing categories of special circumstances. This is really important. And I think the best example of this is when you're in a town where there are layoffs. If you're in a small town and you say, well, this company is closing or cutting back on hours for all of their employees, you may think that every student who works there or who has a parent who works there or a spouse who works there, that they're all going to have the same impact. So I've given this example before, and it seems to resonate with people, so I'll use it again. There was once a coal mining town where the aid administrator of the large school in that area contacted me and said, you know, I've seen things about professional judgment and it always says it has to be case by case, but I don't think that's necessary here because so many people who go to my institution are affected by this layoff and then soon to be followed by a closure of this coal mine due to safety reasons. We talked about some of the situations where it might be similar impact to people. If you have people who all have the same job there, yes, that might impact them in a similar way. But you don't know what other income the family has. So if you have somebody who is married to the vice president of the local bank, that's very different than somebody who has two parents who work at the mine that is closing. So look at your situations where you're sure that they are the same for everyone and document them. It could be that they do apply to what ends up being a group of people, but you'll want to document each individual file, and you'll want to really carefully review to make sure that it is having an impact before you make that decision. So I talked earlier about not circumventing the regulations or the law. Again, for the most part, for professional judgment, you're talking about the law as opposed to regulations. But what we can't do is look at something that's part of the EFC calculation and say, I don't think that should apply. Yes, you can change the various data elements, but you're not changing to the point that you just say, I don't like what that one is, so I'm going to erase that for the student, or I'm going to have that not apply. So for example, if you said, I don't think that taxes paid should be part of the calculation, so I'm going to exclude that from the formula, and I'll see what the new EFC is. That could result in people having a higher EFC. So you can do professional judgment in a way that yields a higher EFC, but you don't want to do it in a way that is erasing the formula. Most people don't tend to do it in that direction. Most people will tend to do it in a way that benefits the student and gives them more financial assistance. But again, you're looking at what makes sense for your student, for your campus. You are doing what you think is the most fair way of dealing with special circumstances. So keep in mind that key phrase of special circumstances. It can apply in multiple directions. You want to make sure that you're not trying to waive the basic eligibility requirements. So we say things like, you must be a high school graduate. You cannot waive that as part of professional judgment. We also want to make sure that you understand the idea of dependency and dependency overrides. You cannot make professional judgment to make somebody who is already independent based on the questions on the FAFSA. We cannot have you go from independent to dependent. Dependency override is, think of it as a one-way street. You can have somebody who's dependent that for various special circumstances you may want to make them independent. You can do that. Some people have asked me when they hear about this idea, well, what would be an example of going in the other direction? Why might I even want to consider it? Well, the idea of going from independent to dependent has come up in multiple sessions where people ask questions. The one that comes up most often is where the student was married and then the student gets divorced. And maybe the student is fairly young and they're moving back in with their parents. And so people say, you know, they're really a dependent student again. We say that you cannot go in that direction. Once they've been independent, they stay independent. So they're not going back the other way. Earlier, I mentioned the idea of having professional judgment on your campus as an option for you. It is an option. We want to make sure that you're establishing an institutional policy to explain how you're doing professional judgment. Some of this is really just procedural. It's kind of good practice. So you want to make clear in your policies if you will consider professional judgment. If you will consider it, to me, one of the most important things to say in there is who is able to make professional judgment. We say in the law, it says the financial aid administrator. So we often will say institutions can do professional judgment. We never say who at the institution must do it or may do it. So keep in mind you do have that flexibility to decide. At some institutions, it is literally any financial aid administrator. You may have 10 of them, and any of them can make that judgment. That's fine with us. At other institutions, they say only our director of financial aid can make that decision. The financial aid administrator who reports to the director might make a recommendation, but it's ultimately the director's decision at that institution. Then we have other places where they say we have a panel or a committee, and the committee gets together every 2 weeks in peak season, and they sit and they review the files. Maybe you redact names and it's somebody from admissions or somebody from aid, and somebody from various offices on your campus. That's fine too. We're not going to tell you with that kind of specificity how you should do your judgments. You get to pick that. We won't impose our thoughts and our beliefs on that. It's just a best practice to say who is going to be able to do it. That said, if you try it and it doesn't work, you can always change it in a revised policy. You don't have to feel boxed in. Try it, see what works for your campus, see if it is working. We also want to make sure you specify, though, if you allow appeals. I say this, generally speaking, to a room full of financial aid professionals. I know from being on a campus and being on multiple campuses that whenever somebody doesn't like something, who do they call? Not your boss. No, we have to go up here. Let's call the president's office. The president's office can make it all better. And yes, for any presidents here, not speaking ill of college presidents. However, who knows financial aid better than anyone on your campus? Not the president. So they hear a story from a student and they say, look, I thought I should get professional judgment, or I thought they should consider my special circumstances. And what happens? You deny it, and they go to the president's office or some other office above you. We try to help where we can by putting out things like this presentation where you can go and say, here you go. Here's what they said at the conference. Don't feel pressured to change your decision based on what you think somebody might appeal, but say in your policy, for your own protection, say what your appeal policy is so that you can say to your president, well, our institutional policy is this. It says that the director of financial aid gets to make this decision and there are no appeals, and they can appeal to the director of enrollment management, or whatever your situation is. But if you put it in writing, you're helping yourself, because then somebody can't come to you and say, well, we want to override that. If it's your institutional policy, keep in mind a program reviewer or an auditor can cite you for failing to follow your institutional policy. Nobody wants that, right? That's an easy finding. You don't have to have that ever. So follow your policy. Make sure your policy is in writing so you can present it to someone upon request. Hopefully that also limits the amount of people who will try to appeal elsewhere. I cannot guarantee that, I wish I could, but hopefully it helps to put that kind of where it belongs. The other thing you can put in your policy is what circumstances you'll consider and what you won't. So I once talked to an aid administrator who said they worked in a city, their institution was in a large city, and the city was known for having very bad, poor quality public schools at the K-12 level. They felt that it was very dangerous to have kids in certain public schools, and they felt really fortunate that there were some very good private schools in their area, but many of them were costly. So they would often hear from people coming in, parents would say, well, I have 2 younger ones that are not ready for college yet, and they're in private school, and we're paying private school tuition because we don't feel comfortable having them in this lower performing school or whatever the situation was with that school. So we talked about it, and some institutions will consider private school tuition paid for other children. Some will consider it the first year only of a student's attendance at the institution, and they say only for the student. Again, I'm not going to tell you what to do. It's your decision as to how to do it or if to do it. You may say in your policy, we do not consider tuition paid, private school tuition paid to a secondary institution as something we will consider for professional judgment. So you're cutting it off right away. You're saying we do not consider this as special circumstances. Or you may conversely say, here are some examples of situations we will consider. We will consider that. We will consider unemployment. You can name them. You don't have to, but it's something to think about, especially if you get a lot of inquiries from people. One of the things I've talked to somebody about one time was they said we often get people saying that they got an offer that's better from someone down the street or across town or across the country. They're kind of shopping for their financial aid at that point. They're trying to leverage one offer of aid against another. And so they said, would it be appropriate to say that we're not going to consider awarding again, or a re-award process or a re-examination based on aid offered at another institution? Sure. If you want to say that, you can. Some people don't feel comfortable saying it, but they think it in their minds. That's okay. Again, we're just giving you ideas here of what you might want to consider. Your institutions are very different. So I can't necessarily come up with ideas for all of your institutions on the spot, but you are probably thinking them already. You are probably in your mind thinking, I have one that comes up on our campus, and maybe it would be good to put that in a policy. So think about it. Again, think about which way you want to go. Do you want to do it as these are the things we will consider, or these are the things we won't consider? I will pause here just to tell you my 5 words in the English language that when strung together, I dislike the most. That is when you give a list to someone and you're trying to give examples. And if you're doing slides, you even put at the top of the slide, examples include. I do not like the words including but not limited to. If it says examples, it's an example, and there may be more. So please make sure that when you're giving examples, you are clear with students that you will consider others. You don't have to use the 5 dreaded words, but just let them know that these are things you'll consider, these are things you won't, but let them know if they have other special circumstances, you advise them to contact their counselor or contact your office or however you want to put that out there. But I do think it's important that if you are willing to consider special circumstances, that you let students know how they can take advantage of that. We don't want it to be this open door where everybody is coming to you saying, I have special circumstances, because we know that they need to be special. And we're going to focus on that coming up soon. First, though, we're going to look at the idea of documentation. And I always say to people, when you're thinking about documentation, you want to make sure that your documentation is appropriate to the situation. Sometimes people get so hung up on documentation, and again, probably because people like me have said to you, you need to make sure you document. And yes, you want to document, but make sure you're not piling it on. Make sure that when you have a student with special circumstances, you're asking for what you need, that it's appropriate, that it's what you need to make the decision. But for example, don't look at this list and say, well, I need 5 of these things on the list in order for me to do special circumstances. Or I need 3 copies of something that says the same thing. Make sure you're not creating burdens for your student. Make sure that you're not asking for something beyond what is reasonable. So I've given some examples, and I think part of what we need to do is somewhat modernize some of our thinking. And many of you have probably already done that on your campuses. We used to have on lists like this, things like copies of canceled checks. I don't know about you, but I've not written a check in multiple years now. Your students are doing Venmo and things like that. They're on their phone, right? But most people have found other ways of making payments, and that includes government, who's usually last to adopt everything. Your state governments, your federal government. Many of us now are saying there are better ways to do this other than checks. So they're not sending checks anymore. There's no unemployment check. There's no benefit check. They're sending electronic payments. So think about, if you haven't already, think about what is appropriate documentation for a situation where you might have otherwise expected to, in the past, see a check. So that might be statement of accounts. Well, remember, many people, myself included, I don't get paper statements anymore because I just have to pile them up, file them someday, and then go shred them. So I don't want to be bothered. I have everything online. I think that's really cool because then I don't have to store the stuff. They store it for me. But remember, your students might be in that situation too, and or their parents, and or their spouse. So they may say to you, well, I don't get paper bills or paper statements. I just can go online and print you something off. Well, in the past, when we were first starting some of the electronic commerce that we do, people would say, well, I don't feel comfortable just taking a print screen from something. When I look at it, it doesn't even look real. It's not formatted properly, and it just doesn't look right. Think about, though, what the student would have access to. One of the things I remember is somebody coming to me about professional judgment several years ago, and they said the person was commenting that they were unemployed. And they wanted to do professional judgment based on that unemployment situation, but the person wasn't getting unemployment checks. And they were looking at the statement, and they said, well, I could look at it in my office maybe, but then there's no paper trail. And I said, but you could print it, or the student could print it. Now, the printed copies don't look pretty anymore, but remember, you're documenting each situation, so why not just document in the file that you reviewed the statement that they have? Whether you saw it in person or not, you could write that down in your file, but don't pressure the student to get more than they need. The person I was speaking with said, well, I was thinking about printing it, but then I thought I should just ask them to get a letter from their state documenting each month's benefits. You could do that. I won't tell you you can't, but think about what that means to the student. If you want that on a monthly basis, that's going to be something extra they have to ask their caseworker or whomever about. Remember, we are very heavily now into self-service. Everything has a web portal, everything has a login and a password. They may not have a person anymore to go to. It's log into this portal and send an email to contact us at whatever. So don't put up barriers if you feel it's appropriate to take a copy of a printed statement that comes from the web, or that is an electronic version of something that was previously paper. And again, think about forward thinking here. What we're thinking of today may change in the future. So as you're thinking about your policies and thinking about what you do, especially if you write policies and procedures for other people in your office and you're trying to maintain some consistency, make sure that you are giving people examples of what might be appropriate or talking through at your staff meetings, that kind of thing. So we talk here about the idea of bank statements. Maybe that's where you see that the same deposit comes in from the state every 2 weeks or once a month. So you're being flexible here. Allow them to redact their personal information if it's not already done. Maybe they want to redact every other transaction. That's fine. Think about things like insurance documents or other agencies that they might interact with. Again, think about the idea of a signed statement. You may be getting things like police reports from people, and again, they may need to redact those names. Be flexible with that. Try to keep their confidence, which you would do anyway, but make sure that they also have their privacy. Allow them to do what they think is appropriate when they're giving you these types of documentation. We also ask for statistical reasons that if you are doing professional judgment and verification, that you make that a two-step process. We like to be able to isolate what's happening with verification versus what's happening as a part of professional judgment. It can get very difficult to see trends and help us to analyze things for verification purposes as we do future years and what the items are to verify if they're being mixed in with professional judgment. So we do ask that you complete verification first before you complete professional judgment. Now that said, I have the word if bolded, which you may not be able to see well on the slides, but we're not saying that you have to verify everyone for whom you want to do professional judgment. But if they have been selected either by the Central Processing Service or your institution, if they're flagged for verification, we ask that you do that step first, get a new ICER back with the new EFC, and then work off of that. So we're going to talk about adjustments. I mentioned earlier there's two ways you can do this, cost of attendance or EFC. Cost of attendance elements are listed in statute, and you are expected as an institution to come up with reasonable amounts for each of these items. So when you think about it, you are going to bill them directly for certain things. Other things, you're making a guess. You're estimating, you have averages that maybe you put into different budgets at your institution. Tuition and fees might even also be an average. But tuition and fees, books and supplies are the two main ones that would be billed by your institution typically. Transportation, personal expenses, then we also have the other items that are more as they apply to students. So things like cost of dependent care, which remember could be a child, it could also be a parent that the student is supporting. Also included as you're your as-needed type of cost of attendance elements would be the cost of first-time licensure exams for a student for whom that applies. Also study abroad cost and disability-related expenses. Remember, Congress, when they talk about the cost of attendance, says you have to, as an institution, establish the amounts for each of these. That said, when you look back here, and I just realized transportation is on the first slide. So transportation is the one that I often think of. Somebody could say, well, I'm coming a long way to go to school and I commute and I have excess charges for transportation. Or maybe you set a budget, but someone is coming from much further and they're taking multiple forms of public transit and their pass every month is much more than what you've allotted. Consider those kinds of expenses. But we'll also talk later about looking at the amounts that the formula already allocates for things in the EFC. So think about the balance in here and how these two items interact. I said earlier we would talk a little bit about IPA. That is income protection allowance. If you've done a hand calculation to compute an EFC, you know all about this. If you haven't done one before, I would encourage you to do one, and I would encourage you to use your own situation to see what your EFC would be, and then start to what I think of as play. Now, I realize not everybody thinks this is fun, but I really do. Actually go do a hand calculation. The worksheets are out on IFAP. And start to think about what would happen if I had unusual medical expenses and I did a professional judgment and allowed for $10,000 worth of medical expenses to be used to do a PJ. Think about some of how those special situations would work. It's easier, though, I think, when you do it with something you're familiar with. And you're probably more familiar with your own personal expenses and budget more than any student that you could look at. So I would encourage you to think about that. But also remember that understanding that EFC calculation and really living it is different when you do a hand calculation as opposed to pushing the buttons to make it happen electronically. When I started in aid, what I think of now as more years than I'd like to admit to, we all had to do a hand calculation every year. And I really found that to be valuable. So think about that as kind of a little commercial for hand calculations. Remember that there is an allowance for many items within the EFC already built in. So you want to determine what these are. You can find the IPA items on your ICER, so they are there and available for you to look at. But I just want to make sure you're thinking about those items and think about the amount that's already allotted for the expense. You know that there is income and asset protection already built into the formula. There's an allowance for employment, the state and local taxes. There's all kinds of allowances built in, and you'll see little worksheets for those items. That stuff becomes invisible the more electronic we get. People don't think about that as much as they used to, I think. So remember these values. I think this slide is really helpful in outlining where your EFC formula goes, so to speak. So they've already allotted 30% for food and 22% for housing. Now, if you look at that, you might say, well, that seems a little odd. I don't know anybody spending 22% of their income on housing and 30% for food. It should be reversed, right? That is not a mistake. The income protection allowance items were written many years ago, I believe in the 70s, when that was true. These pieces haven't been updated, so you get what you get. That said, you still consider these as you like when considering a professional judgment. 9% for transportation is already built in. Medical expenses, 11% of the income. So when you hear somebody say, I had really high medical expenses, you wouldn't believe what I spent. I remember thinking that way this year myself, and I looked at it and I thought, but would it exceed these values? Even though it feels like a lot, when you look at what's already been allocated to that expense, it may not make sense to do professional judgment because you say your $3,000 is already thought of when the formula is done and your EFC is calculated. So remember the idea of cost of attendance, remember the concepts behind the EFC calculation, and use those tools to help you make your decisions about professional judgment. So our first example is the idea of the income protection allowance. If their income is $30,000 and the formula is allotting 11% or $3,300 for medical expenses, think of the student who brings you in documentation and says, but I had medical expenses of $2,500 this year. For someone making $33,000, that seems like a lot. But again, when you realize that $2,500 is already covered, that's less than the $3,300 allocated. So think about it. Would you do professional judgment here or not? Most people would not. Again, your decision. If you can document that there are exceptional circumstances, I'm not saying it would never be appropriate, but use these things as your tools to help you make your decision. In the second example, we'll take someone whose income is $30,000. So considering income protection allowance here, the formula is allotting 9% for transportation, which works out to be $2,700. If they're showing you that they have transportation expenses of $3,600, and I have here for monthly train passes, but I mean for the year. So it would be a $360 charge for 10 months out. Would you use professional judgment here or not? The difference here is $900. That may not seem like enough to justify doing professional judgment. So you may look at it and you put that in the formula and you say, it wouldn't really change the EFC very much. That's your decision. If it changes it a little, you might say, well, it's worth it. You have to decide what's worth it. You have to decide if it's the right thing to do or not. Our third example is when the student's income is $30,000. The formula is allotting 11% again for medical expenses, which is $3,300. If the student shows you documentation of $10,300, now we're looking at a bigger difference. So now you're saying, okay, the difference is $7,000. On a student with income of about $30,000, it might make a difference now. Now you look at it and you see what your EFC would be and you say, I might do that. Again, your decision. You're still making sure you have the right documentation. I'm going to shift now to talk about dependency override. We want to make sure you're considering students, again, in the proper direction. So it's when the student is not otherwise qualifying in one or more of the FAFSA categories. So remember that you're looking at those categories on the FAFSA, things like, is the student married? Is the student over age 24? Is the student a graduate student? All of those categories, veteran of the armed forces. You look at those and you say, does the student meet that or not? You're looking at dependency and deciding on independence based on other unusual circumstances. So here I've listed out those FAFSA items for you. And we want to make sure that you're looking at them for that change or for that difference. What about the student is different? So we have here the items that would automatically make the student independent. If your student that is claiming special circumstances can say, well, one of these applies to me, you don't have to do anything else. You may have to have them update their FAFSA form, but that's it. They would automatically be independent. So if they say, you know, both of my parents are deceased and they've been deceased for 10 years, okay, then they're automatically independent. No need to do additional steps other than, again, that FAFSA correction perhaps. So some of this just comes down to actual counseling and meeting with your students, talking with them, or putting out guidance on your website, that type of thing. But again, just going back here quickly, we want to make sure that if something is special about the student where these items do not apply, you still have the ability to make that student independent if they were previously seen as dependent. Remember, too, that being self-sufficient is not alone a reason to do a dependency override. And we've talked about that in other sessions as well. You cannot say that because the student has his or her own apartment, supports himself, has a good job, that we shouldn't consider them the way the law intends them to consider them. Remember, I said earlier, we're not going to circumvent the formula or circumvent the law. So if the law says that student is a dependent student, they're a dependent student unless you have special circumstances. But the idea that they say, well, I make my own money, I support myself, is not a reason. They are still bound by the law, and you cannot change the formula or the law. So parent refusal to complete the FAFSA and support the student. This is an option that came in a few years ago, and it allows the student who is dependent, whose parents say they will not provide information, and they will not be supporting the student, to get direct unsubsidized loans only. This is generally not a great thing for the student, but it's sure better than nothing, right? So when you look at it, we're limiting the amount of aid they can get. And you might say, well, why would this be a good thing then? It's a good thing because if the student truly will not be supported by the parents and can't get the information, if they would otherwise be a dependent student, you used to have to just kind of stop there and say, well, my hands are tied, I have nothing to offer you. We realized that that was a barrier for many students, and so now we have this, which is good if you need it, but we want to make sure, again, that you're using it appropriately. So we expect you to obtain documentation, first of all. You want to document the parent's refusal to complete the form and explain to them that they also need to say that they do not and will not provide financial support. And they need to include the date that that support ended. So they're giving you either a form that you've created with information on it, or they're giving you a letter. It doesn't have to be typed, it can be handwritten. Whatever you want to take is fine. But you want to make sure that they're explaining the situation adequately enough for you to make the decision. Some things to consider is, how do you determine support? If the student says, well, my parents don't support me and they're going to write a letter to say that, you might want to ask additional questions. Or they might even say to you, well, how do you decide if they support me or they don't? Well, if they're giving the student money for any purpose, that's support. If they are on their parents' insurance, that is support. Now, this wasn't as relevant a couple of years back, but now remember, students can stay on or generally people can stay on their parents' health insurance up to age 26. So they may not think of it as support because they say, oh, I have family coverage and I just never took them off, but I'm not giving them any money, I'm not supporting them. If they're providing health insurance for that student, they are indeed providing support. So keep that in mind. You can accept third-party documentation if the parents are refusing to provide that documentation, if they just say, I'm not signing anything, I'm not writing anything. Maybe a neighbor is familiar with the situation. Maybe somebody at their institution where they went to high school. Maybe a member of their clergy that they're acquainted with. Maybe somebody, a counselor, a psychologist, whatever, knows their situation, is willing to write a letter on behalf of that student. The other thing I will say, just to go back for a minute, remember various things. It's not just one of these items, it's any of these items. So it could be insurance, it could be car insurance or health insurance, but it could also be that they claim the person on their taxes. If they have the same address, then they're providing some support. But I had one person ask me the last time I gave this session, well, what about if the parents have the kid over for dinner every week? Is that support? We generally don't go quite that far in making those decisions. That is your decision. I found that most people, if they're having the student over for dinner every week, they do other things for that student. But you can ask those questions. And I don't want you to be afraid to ask what you need to ask to make the determination. But I also want to make sure you're kind of walking that line between intruding too much beyond what you need to know. If you have the letter, we're not requiring you to go out and prod further. If the letter says, I do not provide support, I will not provide support in the future, I'm not going to fill out the FAFSA, and the date the support ended was January 1st, 2020, okay, you can call it a day. If you want to go further, we would not say that you couldn't, but you are not required to. Remember, the student is still completing the FAFSA form. There is a process that you would then go through that's more operational than we need to get into here, because you're probably pretty rarely doing this. So if you need some help, give us a call, we'll help you, walk you through it. But generally speaking, that the student is still completing the FAFSA. They are not going to, of course, put parental information on there. The idea of denying or reducing direct loans is kind of a hot topic with some people. And this one is outlined in the Higher Education Act as well in Section 479. There are multiple requirements here that you need to be considering. The first one is that idea of case-by-case basis again. We come back to that all the time with these types of situations. You can refuse to certify or originate now a direct loan. You can also originate a loan for less than the amount that the student's need is, but again, case-by-case basis, And this one is tricky because you want to make sure you're doing it for the right reasons. As with everything else, you're documenting the reason and providing it in writing, in this case, to the student. We think this is so exceptional. Congress has decided that you must, in writing, notify the student of the reason for your decision. That's pretty key. We want to make sure that you're never discriminating. That's also really key. Now, you may look at what I have here on the slide for protected classes and say, well, that's not right. That doesn't include everything that I think should be there. Keep in mind, this is from the statute. So the statute lists out in it very specifically what the protected classes are. And that's race, national origin, religion, sex, marital status, age, or disability status. Those are the items that Congress, when they wrote the law several years ago now, said were the items that you could not discriminate against. That said, as a financial aid professional who wants to do the best for their students, I would hope that you would not discriminate for any reason, even items that are not in here as protected classes right now. We talk about the idea of case-by-case basis, refusing to originate, or reducing the amount. You're documenting this, and yes, that's important, but we also want to make sure you think about why you're doing it. I've often had people say, well, this person has so many loans already, if they come to my school and borrow more, they're never going to be able to pay it back. I would probably start by asking you how you know that. Did the person say to you, I never intend to pay this back? That's different. But if the student says, well, yes, I have a lot of debt, but now I'm going to do this profession, and I really feel that I'll be able to pay it back. The interesting piece of it is, we have found in multiple studies that we've seen that the amount of debt does not correlate with default. People often think, well, I want to do the right thing. I want to help prevent default. And I think that's a great goal. I want to help that too. But that said, having more debt typically doesn't mean the person can't repay it. Often when they have more debt, they've been a graduate student. And then they end up, generally, making more money than they would have otherwise. So they're able to pay the higher debt back. So we wouldn't want you just to look at the amount and say, well, anybody who comes here with more than X amount, I'm going to consider either reducing it or refusing it. You want to make sure if they're coming to your institution and they're eligible for aid, they meet the other eligibility requirements, that you're not just saying no because you think it's the right thing to do to prevent default. That said, default prevention items are really important, and there might be a case where someone comes in and you think it's appropriate. But again, document it really carefully. Make sure that there is no pattern or practice that denies somebody due to those protected classes. Make sure you're keeping your documentation. Think about what does correlate with default if you're trying to up your default prevention efforts. The single factor that most impacts loan default is failure to complete the academic program. So if you're trying to ramp up default prevention activities, consider your retention, consider what support services your institution has. I guarantee you if you do that, you'll be much better positioned to help students than just saying, it costs this much to do your cost of attendance, but you can't have the money for all of those things. The other thing I've sometimes heard is people saying that they limit the amount based on what the student has to pay to the institution for direct costs. Remember that list I showed you of cost of attendance elements? Remember, the student needs all of them to come to school, not just some of them. So if you're limiting it to direct costs, then how does the student pay for things like transportation or food or possibly housing if they're living in off-campus housing? You want to make sure that the student can afford to stay in school. When I worked in compliance, I had students who were calling me after I did a program review at their school, and they said, we're not able to get credit balances here. They're not giving us any money back to use for living expenses. So the one student was crying and she said, I'm going to have to drop out. And now I've already taken on some debt, but I can't stay in school without my living expenses. We're not talking about excessive living expenses. They still need to be on a student type of budget, but remember, you're setting that budget. So if you're concerned that students are borrowing what I'll say in air quotes is too much, Remember, you are setting those cost of attendance elements. You may want to revisit them. Maybe they're not appropriate anymore. Maybe some costs have gone down and others have gone up. So make sure you're just considering all of those different factors before you're doing something like making a professional judgment in any capacity. Also, I think because this one is so sensitive, this idea of denying or reducing loans, you may wish to consult with legal counsel at your institution or your risk manager or also other senior leaders. Any of them may be able to help you to make that decision, and also not so much to help you make the decision, but to back you up if you make the decision, right? Because nobody wants to be overridden by someone else. So make sure they're on board with your strategy. If you say, look, this is why I want to do this, you'll have a sense as to whether they agree with you or not. Questions? Nobody came up and flagged me to say, stop right now, I have a question. But we are at that question and answer point. So if you have questions, please line up at the microphones. We do ask that you go to the microphone because some of these sessions are recorded and we want to make sure that everybody can hear your great question. And just for the record, I said I wanted to allot 15 minutes for questions, and I did. Mark.
Hello? Oh.
Hello.
Sorry.
There we are.
Oh. Now they did. My name's Mark Antrowitz. I'm a publisher of SavingForCollege.com. I'm also the author of the only book about professional judgment. I have a comment and a question. With regard to the case-by-case requirement, there is an exception to that in the HEROES Act. If there is a natural disaster, they can waive the requirement for a case-by-case review of the circumstances. The question has to do with the asset protection allowance. As you're probably aware, the APA has been slowly disappearing, and the maximum APA this year is under $10,000 for the first time. And historically, financial aid administrators felt comfortable with kind of being hand-wavy around assets because they knew that for most families, and back in 2009, you could have over $80,000 of assets ignored by the APA. But now that it's on its way out, and within another year or two, it's going to be completely gone unless Congress and the department do something about it. Now colleges can't sort of say, okay, we're ignoring the assets because that's already taken care of the APA. So what should a financial aid administrator, or can a financial aid administrator do if they have a family who wants to have some of their assets sheltered or ignored and there's no APA left?
So there's a bit of an echo. I'm having a hard time hearing parts of the question, but I think I've gotten enough of the sense of it. But if I'm not quite getting at what you need, please let me know. So you're talking about the idea of asset protection, and yes, it is slowly, unfortunately, disappearing. We've also said that you can't do professional judgment to circumvent the formula. So what I would recommend is, if there's another way you can consider what you're trying to accomplish, to look for other methods to get you there. If it's a matter of saying, well, there used to be asset protection and now there's not, every family is in that same situation. It's not unique to a particular person, so I wouldn't see that as special circumstances. But if you have other ways that you can get to special circumstances, if there's something else about this family that's unique, I think that's fine.
Hello? Okay. Mic wasn't working earlier. Can you hear me?
Mostly. There's still a bit of an echo, but we'll give it a whirl.
Okay. So you mentioned earlier that sometimes the EFC can go up when you're doing a review. And my question is basically, as an FAA, if you see that the EFC is going to go up, can you then decide we're not going to go forward with this review, or we're just going to leave things the way they are?
So I'm just going to restate the question quickly, and again, if I get it a little off, but I'm concerned that as other people are hearing it, you might be getting some echo as well. The question is essentially that if you're looking at doing a professional judgment and the EFC goes up, can you as the aid administrator decide not to go any further? And the answer is absolutely. You can say, that's not what I intended, I thought I was helping this student or family, and it's not helping them. There are some cases where that could definitely come into play, especially when you have students who have higher incomes. Make sure you're checking your decisions and looking at what that EFC would be. Many systems have a way that you can test out a temporary change of what the EFC would look like if you made this change. You don't have to complete it if it's not going to work for the person. If you do go ahead and you process an ICER with that higher amount, remember, you as the aid administrator, as the institution, can still decide which is the proper ICER transaction to pay off of. So even if you went ahead and processed it, you wouldn't have to use it. And the other thing I didn't mention that I should mention quickly is that you don't have to honor another institution's professional judgment. So if you've seen somebody else did one and the student tries to say, well, they did it at the other school, you have to decide individually if you think it's right for your institution. Back over here.
Hi. My name is Debbie Yeager. I'm a financial aid compliance officer as well as a private consultant. Some institutions have asked of me a situation that has arisen with their business office. They have had parents who have borrowed large sums for dependent students through their Parent Plus loan, and then way above the tuition and book charges, etc. And then the business office is required to return money to either the student or the parent. Do they then have the ability, if they've seen it happen multiple occasions, limit the amount of money that the parent borrows? Because it's not, I realize that this loan is not need-based, but they feel that it's possible that they're not using it for what originally was intended to be for.
So I would caution you when thinking that somebody is not using the money for its intended purpose. The student is signing on the FAFSA form, and if the student is dependent, the parents are also, one or both parents would sign, generally one, or if it's a spouse situation, the spouse, of course, signs. They are certifying on there that there's a statement of educational purpose. It used to be more separated, but it's part of the FAFSA form, and that's part of what they're signing. So they're already affirming to you that they're using the money for educational or education-related expenses. If the cost of attendance for that student holds the amount of loan, it's really tricky for me to say, well, they're not using it for the right thing. Because you're going to say, well, they're entitled to this much money and they need that for their costs. However, they don't need it. Now, that said, there could be examples of where that's exactly what you might want to do. It may be that you say, well, this student is getting, they're getting money from some other source, and it's not technically reported on the FAFSA, maybe it's in-kind support, but it's enough and it's significant enough that you say, I'd like to do professional judgment. If you do professional judgment to count that as other untaxed income on the FAFSA, you're not really reducing the loan, but you're changing their need. So that's kind of what I mean about looking at this as a more fluid situation. You're not necessarily saying I'm going to reduce the loan, but you're looking at their EFC calculation and you're looking at their cost of attendance. If you know, for example, that someone else is paying for their living expenses, maybe they are an RA, for example, they're a resident assistant on campus, or maybe their spouse is in a job where housing is provided for them, then you can reduce that living expense item for that student. You don't have to reduce the loan, but you can do it on a change in an EFC element.
I appreciate what you're saying, but in these particular situations, what's happened is that, as I said, they have expenses, tuition, books, etc., They include, as they bill, as the financial director of financial aid builds the cost of attendance, its transportation, personal aspects, etc. Possibly they get a federal grant, they get federal student loans, the student themselves, and in order to cover the remaining tuition charges or whatever else they're obligated to pay to the school, they need, let's say, $10,000, and they borrow $30,000, and it's a feasible amount because it's not going over their cost of attendance, but they're getting a refund of a lot of money. And the school then says, well, I have to, cut a check, blah, 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 blah. And if it happens once, possibly, or twice, can they limit the amount that the parent takes out? That's the concern.
So the idea that they're getting a credit balance amount multiple times, I would be very careful with the idea of saying they don't need it. Because again,
Right.
if that institution has a cost of attendance that can hold that amount, it's tricky to say that they are using it for other purposes.
Right, right. I mean, we don't know what their personal obligations
Right.
are, Thank you, I appreciate that.
Sure. I'm seeing from my monitor in the back, it says stop, and I thought I had 5 more minutes. But I'm being told stop. I'm being told no more. So I see that I've got a couple more people with questions. If they are quick questions, I can take them before I dash off to another session, but I do have to yield the room to someone else. So I will take them kind of down here if that's all right. If you would prefer to email me, that's fine too. I thank you for being here, and I do wish you the best of the rest of the week. Okay. I'm going to get off mic.